listening to Legacy Lawyers, hosted by Michael Haslam and Nathan Croxford.
Hey, everyone. Thanks for joining us for the Legacy Lawyer podcast.
I'm already cracking up.
We're having a lot of fun trying to figure out why my video makes me look like a ghost.
I just said he looks just like Casper.
Like all washed out, fuzzy.
Like Casper the Friendly Ghost.
Whoa.
And for those of you that are just listening to this on audio, which is probably everyone, I'm sorry you don't get to enjoy this. We are going to be upgrading our podcast to create primarily a visual version. It'll obviously still be available on all the podcast platforms in audio, but there's just too much good stuff. Like, you should have seen Mike as a ghost. It was awesome.
Well, it's fitting. The other day I was at the beach with my brothers and took my shirt off and they're like, whoa, you're almost paler than Dad.
I don't know why I'm finding this all so hilarious, but
Like, do
you tan at all?
Yeah, I tan great. I just try to stay out of the sun so I don't get cancer.
Oh, but I thought, don't you have a little bit of the redhead going in you? Or is that so your kids get that from your wife?
None of them have redheads. I don't know what you're talking about. There's blondes. I got some blondes, and that's from my wife's side.
I'm gonna have to come in and look at the pictures closer. I think there's some strawberries.
Yeah.
Strawberry blondes. And they all tan well?
No, I mean, probably not. Probably below average.
Okay.
Well, I don't know what any of that has to do with our topic today.
I do. There's a concept out there that it is a ghost, because may at times appear real, but in fact it's ephemeral. There's a word for you.
Yeah.
And it's also probably scary a little bit. It's certainly scary when I hear it, when I hear how people are interpreting this particular tax code provision. So that's the tie-in.
That's perfect. So we heard about this ghost over the last year and a half. We're getting calls.
Yeah, and that's a big deal, because if this was a thing,
It'd be the coolest thing.
it would be cool. But as it is, you could very easily find yourself in some serious hot water with the IRS if you go down this path. So why don't let's start out. And when we upgrade our podcast, we're going to put what's the thing I'm trying to come up with? The qualifier, the disclaimer. There you go. We're going to put the disclaimer in there at the very beginning, in the intro, or at the end, so that we don't have to say it every time, because I'm frankly tired of saying it. But let me say it one more time. We are both attorneys. We both do estate planning and business planning. However, the purpose of this podcast is for educational and entertainment, for your education and entertainment only. It is not to be a substitute for legal advice. It is not legal advice. And we always advise you to find a qualified attorney to look at your specific situation and give you actual legal advice. So with that being said, what is this ghost strategy, and
so
I've
gotten several calls over the last year and a half where clients have called and said, hey, someone told me if I put everything in a trust, and by everything, like their real estate or their business, some asset they're looking at selling, that when I sell it, I don't have to pay taxes. And so I'm like, well, maybe they're talking about a charitable remainder trust. There's a couple specialized trusts that work in that vein, but there's some trade-offs. Like, you get to avoid taxes, but then assets have to go to a charity, or
you get to avoid some taxes. The money's coming out of one of those charitable trusts, that the part that's coming to the client is still taxed.
But then as I kind of asked more questions, they're like, no, they said there's no charity involved. Okay, so it's not a charitable remainder trust. And as we talked through it, I'm like, that is not a thing. And so finally I drilled down enough to get what IRS code section they're talking about. So there's a section in the IRS code section called 643, and there's a paragraph B that talks about trusts.
And just so you know, anytime there's a section, and that's one of the main features of a trust, lawyers always end up calling it in this case, a section 643B trust, which makes it sound very official and, legitimate and all those things. So just because something has a section before the trust name doesn't mean that it's legit.
And I haven't found any attorneys promoting this strategy, although I think there are some law firms participating in this on the back end somewhere. But I'm mostly seeing
good reason for that, Mike, because I think you could very easily find yourself in hot water with a court and with a bar if you went too far down this 643B trust rabbit hole. Because there's very, very, very few instances where you don't pay taxes. Let's just be clear about that. And there are even fewer legitimate ways that you don't pay taxes.
The Congress and the IRS, they work really hard to make sure everyone pays taxes when an asset is sold. Mm-hmm. So that's the first thing to keep in mind. So the idea behind this trust is you take your asset, you put it in an irrevocable trust, and this trust gets its own tax ID number, so it's like its own tax entity. And then they rely on this code section to say, hey, when you sell an asset, you don't have to pay capital gains tax on it. And what's happening is they're taking this code section completely out of context and they're using it to promote this tax strategy. So as I was doing a little deep dive on
to make money, they're using it to try to sell it to people as a legitimate way to do planning, business planning, well, any kind of asset planning. I think this would probably, correct me if I'm wrong, but didn't most of those phone calls come from scenarios where people were selling businesses?
Both. I got one where it was real estate, and then, but most have been businesses. And so we've mostly been seeing it from some financial planners recommending it, and some not even CPAs, but like enrolled agent type tax professionals. So I think one CPA did also promote it, but I guess it's been like this big marketing thing, so much to the fact that the IRS, their Office of Chief Counsel, did a memorandum back in August of 2023. So about a year ago, they did an in-house memorandum where they looked at this strategy, and they said, hey, based on what we know so far about what everyone's recommending, this is our opinion of it. And
I think the term you used was, they described it as abusive.
Yeah, so they think this strategy is abusive. Now, the IRS...
abusive to the tax code, right? Like abusive to tax laws in general.
Yes. It's not within the context of what the code was designed for, so they think this is an abusive strategy. And to be fair, though, the IRS has taken the position on things in the past to say it's not allowed, or the code section doesn't allow it. And upon further review by the courts disagreed with them. But it's gone the other way probably more than
definitely more than half the time.
Yes. And so when I read the opinion from the IRS and I looked at the supporting material that professionals are using to promote this, I've always read it like the IRS. So the idea, and why it gets confusing, is when you set up an irrevocable trust, it's its own taxpayer for tax purposes. However, it can sometimes send a K-1 to the beneficiaries of the trust. So sometimes a trust, even though it earns income and it needs to file and report that income, if it sends a K-1 to one of the beneficiaries, that beneficiary instead would report the income on their tax return. So the trust doesn't pay the taxes on that transaction. Or if the trust did, then you'd have double taxation, right? The trust paid tax on the deal, and then the beneficiary paid tax on the same transaction. So what the IRS needed to create is a code section to clarify when should the trust be reporting the taxable event, or when should they be taking it as what I always call a deduction and sending it on a K-1 so the beneficiary can report the taxable event.
Yeah, and that part, that procedure, that mechanism of trust having income and sending a K-1 and passing that income through to an individual who then reports it on their taxes. There's nothing controversial about that. We do that all the time with different types of irrevocable trusts that we use in our firm. But it's the next part that's problematic.
So when they read this code section, the code section's talking about what we call like fiduciary accounting. Like the trust needs to keep track of what it earns from income or sale of assets. And then the trust needs to decide if that needs to get reported by the trust or passed on and be reported by the beneficiary. So this code section says, hey, if there's a capital gains sale, then this income can be reported not by the trust.
If there's a capital gains sale, what do you mean by that?
So if you sell your business, right, and you get $1 million for it, normally that would be, yeah, if your business is owned by this irrevocable trust and the trust sells the business and now the trust receives $1 million, and let's say it was all profit, then normally that would get reported as capital gains.
As opposed to ordinary income, which therefore the taxes are going to come out differently on it. It's a more favorable, generally capital gains taxes are better than ordinary income taxes, the rates.
Yeah, so it would be distributed at a lower, I mean, it'd be
at a lower level.
So this code section says, hey, if a trust sells something that could have capital gains, so that's the same with real estate. When you sell real estate, it's usually capital gains if you've held it over longer than a year. Stock, if you own a big position in stock, that can be capital gains as well. So someone if you bought Apple, 20 years ago and you have all this gain in your Apple stock, can I transfer it to this trust and then have this trust sell my stock?
The taxes on it.
And not pay the taxes on it. Can I transfer my piece of real estate to this trust and then have the trust sell my real estate and not pay capital gains tax? My business, not pay capital gains tax. So it has huge ramifications and sounds awesome.
I've been doing this long enough that it scares me. It doesn't sound awesome to me. It sounds like a perfect way to end up. I don't know. It just sounds
too good to be true because
sounds scary, like a scary ghost.
So it's a strategy that sounds awesome. A lot of people would love for it to be true. There's a lot of people promoting it, saying, hey, this is going to work. But I haven't found any case law, any private letter ruling, any example, except for they're just reading this code section saying, I interpret the code to allow this. And the reason they're reading it wrong is that code section is just explaining on an accounting basis, not on a taxable basis, on whether or not you should count something at the trust level as capital gains or if it should go on a K-1 down to the beneficiaries. And the statute does have it could be a little more clear. It could clarify, right there in that same paragraph that it doesn't get reported by the trust, but will be reported by the beneficiaries. If they just add that last part, shall be reported on the K-1 that goes to the beneficiaries, then there would be no wiggle room for someone to make an argument when they say it's not reportable. It means it's not taxable. They don't have to pay any tax on it ever. So the opinion that's done by the IRS's Office of Chief Counsel on this is really well done. And I've seen multiple other attorneys who are really reputable in this space agree that the IRS's interpretation is the right interpretation and that these 3B trusts that people are promoting are not going to hold up. And so think about that, Nathan. You sell a business for, let's just say, $2 million. You don't report the capital gains tax. 3 years later, the IRS gets around to doing an audit. You're going to have
penalties. You're going to have failure to report penalties, failure to file penalties. You're going to have failure to pay penalties. You're going to have interest. Not only that, but you're going to owe the taxes. So you're going to owe the back taxes. You're going to have penalties. You're going to have interest. All I can say is that I hope the people that are promoting this as a strategy are advising people to take what we know they should be paying as capital gains and putting it in a very safe location and holding it for, and actually taking a much larger chunk than they would have had to pay in taxes originally and holding that in some sort of a very safe escrow type account where it's like, okay, we're going to see if this flies. And if it doesn't, we dang well better have the money to pay up.
Yeah, I mean, it's a very, very risky strategy because you do. And then if they feel like it's abusive enough, then there's civil penalties and even they could bring criminal charges.
Yeah, I mean, I think that's where, I think you're absolutely right. I know you're absolutely right that there have been times where the IRS comes out and they see a strategy and they issue an opinion, informal or interior or, internal opinion, and they call it abusive because maybe they don't like the impact that it's going to have if people start using it on a regular basis. And ultimately, a court disagrees with them and rules in the other direction. And it turns out that's a completely legitimate approach. Here where I think the warning they're giving is the reason they see it as abusive is because somebody is taking a small little narrow provision in an otherwise larger statute and trying to make a broad application across the whole landscape of that statute, just using that very narrow provision. And that's, in that instance, that's where it becomes abusive. And so you have to be very careful when you're doing things like that you don't cross the line. Even if you're willing to walk on that fine line, you got to be careful that what you do doesn't ultimately end up being viewed as a criminal tax evasion. Mm-hmm. So well beyond needing to pay the taxes, pay the back taxes, pay the penalties, pay the interest, pay the civil penalties, or whatever the civil consequence is, you willing to do some time for this and have your entire reputation wiped out as now you maybe committed a felony?
That's why I'm surprised the promoters, I'm like, man, those guys, they must be really comfortable with risk because I think they have some exposure if the IRS audits some of these and they come back to them for promoting.
For sure. I mean, I'll give you an example if we have time for one real quick.
Yeah, let's do it.
Where a law firm in Utah, a very reputable law firm in Utah, that is no more. I mean, it had been around for, I want to say, close to 80 to 100 years. And that firm took they had a couple of, I don't know if, to me, as I recall, it's been a long time since I read the facts of this, but as I recall, there were a couple of attorneys in their tax practice group that took a very aggressive strategy and promoted it heavily and had a lot of clients tied up in that. And ultimately, it wasn't the liability from the clients that ended up being the problem. Ultimately, it was penalties the IRS had assessed against the law firm for promoting the strategy. And that law firm felt like they still had some basis for defending against those sanctions. And the sanctions were something like, several tens of hundreds of $1,000s a day that the penalties and interest and fines weren't paid. And they kept messing with it and kept messing with it. And years down the road, ultimately the court ruled against them and that law firm dissolved. They had to dissolve the law firm sell all the assets to pay the tax bill, and that law firm doesn't exist anymore. So it's serious.
So I have some tips for what you should do if anyone recommends a tax strategy that sounds too good to be true.
Yeah, this is good stuff.
So first, ask as much details about what tax code section they're relying on to make this recommendation. They
Do
should
not
have,
let them be vague. Drill down, ask questions, have them send you the provisions, make them show their work. And then,
ideally, they have an actual legal opinion letter from either their own company or somebody where there's someone saying this is the strategy and this is how it works. And they have thought through all the legal arguments of why it's a valid strategy.
so if that exists, get that too. But at the very least, get the specific section they're relying on and so forth. Because then what you're going to do is you're going to go out and get a second opinion.
Bing, 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 bing.
And maybe a third.
Probably a third even. If the next two people, even if the next person says it's good or not good, go ahead and get a third, because people can be wrong sometimes. So the second opinion could have told you no, it's not valid when it might be. So,
and I would say even as part of that, getting those second opinions, like I realize that not everybody's going to want to read the code and drill down on the details and get into the nitty gritty. They're going to want to rely on professionals to tell them whether or not it's legit or not. But just as a general matter, if it sounds too good to be true, it probably is.
mm-hmm.
I've never, maybe never is the wrong word. I rarely, if ever, have heard a strategy that sounded just sounded amazing, like, and gave the taxpayer huge tax benefits that turned out to be legit.
Yeah, usually they're very well established strategies that you can find multiple sources to confirm that they're legitimate and that they're valid. And so if that's not there and your second opinions don't agree with it, then just run for the hills.
Here's another thing that I think happens, and I've seen this because I've watched clients sell businesses. You have such a large amount of money coming in, and the potential tax bill is so daunting and scary and huge that you almost you want to believe that something like this exists, because you're desperate not to pay the kind of taxes that are generally going to come due when you have a big exit from an asset. Big capital gains, sale of a business. That's where I've seen it the most, is sale of a business, where it's maybe life-changing generational type money that is coming into a family's hands, and they desperately want to know how to get the best tax outcome. And they hear something like this, and it's hard to dissuade them that it's not a good idea. It's hard because they so want to believe it's true. So don't let the size of your exit or the size of your asset, sale, the amount of money that's coming in, don't let that override reason and your gut. You should always listen to your gut, and you should always listen to, logic and reason.
I think that is really good advice, Nathan. So if you guys hear any recommendations about a trust that avoids special taxes, make sure you follow those steps and reach out to a trusted advisor, someone like Nathan or I that really, really deal with trusts on a regular basis and understand how they work really well, and just be smart about it. So any last thoughts on the 643B trust? You got one set up, Nathan?
No, I don't have any. I've not established a trust under Section 643B. I don't have any intention of doing so anytime soon. I'm going to sit back and watch how things play out over the next few years for people that have actually done this, because that's where you find out what the real scoop is you give it a while to kind of proof of concept. And if the IRS is dead wrong, then I'm all in. If we get an appellate court that comes out and says this is legit, then we'll start promoting it.
I don't see that happening. And if a court did do that, I think this is something Congress would act on.
Yeah, and that's the other thing, is that when Congress doesn't like an outcome that a court has come up with, they can always go in after the fact and legislatively change the code to plug that hole. And that's happened countless times, where, because you know what, sometimes there is a genuine loophole and it was inadvertent, and you know, the drafters of the code didn't see it or didn't see the consequence of it until they saw it play out in a court of law. And the court basically says, our hands are tied. This is what the statute says. This is for sure legitimate. And then you feel like there's going to be this huge rush for people to go implement this at the very next legislative session. Or if it's a big enough deal, there's maybe an emergency legislative session that's called, because they're like, we have a huge hole in the boat and water is going everywhere. We got to plug it. And they get in there and legislatively shove a cork in that and plug that up and glue it shut, nail it shut, bolt it shut.
Yeah, both political parties are pretty much in agreement that if you sell your business, real estate, or stock, you should pay capital gains tax.
The disagreement comes in how much, at what, you know, how much should you pay? What are the rates? But as a general rule, you sell a business, you're going to pay some taxes.
So I think that would get quickly shut down. So, all right. Well, thanks for joining us for this episode. We hope it was educational and entertaining.
Mike, try not to be such a ghost. Get out in the sun. Get out in the sun once in a while, for the love. Like,
Just in here reading IRS code section. I don't know when I'm going to do.
Least, you're going to take your shirt off. Have a rash guard on so you don't hurt people.
Thanks for the tips.
You're welcome. Just trying to make good family experiences. All right. Thanks, everybody. We'll catch you on the next one.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.